Welcome back to This Week in Immigration. I'm your host, Hannah Jordan, Communications Coordinator at the Bipartisan Policy Center. In today's episode, we're covering some recent immigration litigation, including a Supreme Court ruling that dismissed state challenges to the Biden administration's deportation guidelines, a long-running court case about the future of the DACA program, and another lawsuit against the Biden administration, this time brought by the American Civil Liberties Union against new restrictions on seeking asylum. To help us unpack this flurry of litigation, who better to join This Week regular Teresa Cardinal Brown than Steve Yale-Lair, Professor of Immigration Practice at Cornell Law School. Stay tuned.
So given the diversity of strongly held opinions on immigration, it's unsurprising that immigration policymakers often find themselves at the center of intense legal battles. Recently, we've seen a large volume of litigation from actors across the political spectrum. Longtime listeners to This Week in Immigration will recall our regular segments where we update on the latest important court cases on immigration. So it's time to dust off our sound effect because we're here with the latest edition of The Gavel. So in the past, you've had to listen to me, a non-lawyer, try to break down these litigations. But today we have a real lawyer on and an expert at that. So to help us understand several recent and ongoing cases and their significance, we are delighted to be joined by Steve Yale-Lair. Steve has practiced immigration law for over 35 years. He is co-author of Immigration Law and Procedure, a 22-volume treatise on immigration law that's used in law schools around the country. He also teaches immigration and asylum law at Cornell Law School as professor of immigration practice and is of counsel at Miller Mayer in Ithaca, New York. So Steve, welcome to This Week in Immigration.
Really glad to be here.
So let's start with the recent Supreme Court ruling that rejected a challenge from two states, Texas and Louisiana, to the Biden administration's deportation guidelines. So this was a bit of a surprise 8-1 decision, with all but one justice ruling against the states in this case. Many decisions of this court have been much more evenly split. But can you tell us a bit more about what this case was about and what the decision said?
So this case started back in September of 2021 when Secretary of Homeland Security Alejandro Mayorkas issued a memorandum on enforcement priorities. The memorandum explained that because the Department of Homeland Security does not have the resources to apprehend and deport all 11 million or so non-citizens who could be subject to deportation, immigration officials should prioritize who they apprehend and who they put into deportation proceedings. And he said, let's focus on three specific groups: suspected terrorists, non-citizens who have committed crimes, and those who were caught recently at the border. Texas and Louisiana didn't like that. They sued in federal court in Texas to challenge the policy. And they found a U.S. District Judge, Drew Tipton, who agreed that that enforcement policy memo violated federal immigration law, and he vacated it nationwide. The Biden administration then went to the Supreme Court saying, hey, we've got to put this in place. The Supreme Court agreed to take up the case, but for the time being, it held the injunction in place so that it was not in effect until they ruled. So you asked, what happened at the Supreme Court? Well, originally the justices agreed to review three separate questions. The first was whether the states had a legal right to sue at all. That's a concept known as standing. The second was whether Texas and Louisiana were right in that the federal immigration law requires the federal government to detain all non-citizens, not just those that they prioritize. And the third question was whether the judge had power to block the Biden administration from implementing the policy nationwide. In the end, the justices reached only the first question, whether Texas and Louisiana had so-called standing to bring their lawsuit. And as you noted, the Supreme Court ruled 8-1 that they did not have that legal right to challenge it. Therefore, the justices did not weigh in on the legality of the policy itself or whether a nationwide injunction was appropriate. And Justice Brett Kavanaugh wrote for the majority. That included Chief Justice John Roberts and Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. And as we'll get into in a minute, Justice Neil Gorsuch wrote an opinion in which he agreed that the states did lack standing, but for different reasons. And then we have Justice Alito, who dissented. And I can get into more of the details if you want, or I can stop here.
So let's talk about this standing question. So, the legal concept of standing, as you said, is like who has the ability to sue when somebody believes that a law has been violated or something, the government's doing something wrong. And obviously, in this case, the Supreme Court said, well, at least with regard to this type of an issue, the states don't have standing. So I would ask you maybe who would have standing in this kind of case? Like, what does this concept of standing mean, particularly if you can talk about it in context of some of the immigration lawsuits that we've seen?
Standing is a general concept that we teach in law school, saying courts don't want to weigh in on theoretical or abstract issues. They want to know that it's a real case and that real people have been heard. And so one of the requirements generally for standing is that there's an injury in fact. It's not hypothetical. Recently, the Supreme Court has said, well, what about states? States aren't private parties. If the state, tears down my house, I can sue them because they caused me damage. But what if a state wants to challenge, say, an environmental regulation, but the regulation has not gone into effect yet? Should they have standing to sue? And in a case called Massachusetts versus Environmental Protection Agency, the Supreme Court held that states suing the federal government in their sovereign capacity as a state are entitled to something known as special solicitude, meaning that, yeah, you're a state and you gave up some of that sovereignty when you joined the union. So in return, we, the courts, are going to make it a little easier for you to sue when you're challenging a federal regulation. And that's what Texas and Louisiana were relying on, was that special solicitude doctrine from Massachusetts versus EPA as a way to get into court here. And here, the justice has said, no, sorry, that special solicitude thing doesn't apply here. There's been no injury that Texas and Louisiana have suffered yet. You can't say that more undocumented people are going into Texas because of these enforcement priorities. And so Justice Kavanaugh focused on the fact that this was really a prosecutorial discretion kind of case, not an injury in fact case, as the reason why the Texas and Louisiana could not even sue.
Yeah. And we can talk about the decision a little bit here, because one of the things he said was essentially, you're asking us to order the government to arrest people. And you can't do that. We can't, the courts can't go to the federal government and order them to make an arrest or to prosecute people. But there were some exceptions. So can you talk a little bit about what Judge Kavanaugh wrote in this decision, sort of the grounds that he talked about, like why is this different maybe than other cases?
Yeah, Justice Kavanaugh basically said here, no administration, Democratic or Republican, is going to have enough money to be able to arrest or deport all of the people who technically may be subject to deportation. So they always have to make decisions about who to prioritize. And that balancing process, Justice Kavanaugh wrote, really leaves courts without meaningful standards to assess the executive branch's decisions. So courts aren't really the proper forum for resolving claims that the executive branch should make more arrests or bring more prosecutions. And he said that if we agreed with this novel standing argument by Texas and Louisiana, then there'll be complaints in the future about all sorts of things that the executive branch does, whether it's drug laws or environmental laws, et cetera. And, we, the federal court, should not be in the business of overseeing what the executive branch theirs. But Justice Kavanaugh did say this is a narrow decision focused on the facts here about prosecutorial discretion. And he said there are, maybe 5 different exceptions there that where we might consider that states do have standing to sue on immigration. Clearly, if states were fiscally harmed, by immigration decisions. Say maybe the federal government took away money from Texas or Louisiana on some immigration policy decision. Then they've been harmed in fact, and they could sue there. And they also said that the calculus might change if the executive branch decided not to prosecute anyone in immigration. Then there might be a reason why Texas or Louisiana could say. And another example that the Supreme Court mentioned was, well, what if you're challenging not just their prosecutorial discretion, but also the fact that they're providing benefits to people? And that could lead to a different standing outcome, according to Justice Kavanaugh. And that gets into the Deferred Action for Childhood Arrival program that we'll talk a little bit about later. So the justices agreed that this is a narrow decision. They all agreed that Texas and Louisiana could not sue, except for Justice Alito. But the rationale of what they did was very different among the different justices.
Yeah. So let's talk about what this means right now for this deportation policy, the prosecutorial discretion memo, Secretary Mayorkas's memo. What happens now?
Now they finally can go forward with that September 21 memo and say, okay, we're going to prioritize who we want to put into deportation proceedings. And that's a good news for the government, and we'll see what they can do in terms of trying to ramp up deportations, focusing on the enforcement guidelines set forth in that 2021 Mayorkas memorandum.
So let's talk about what that means on the ground. Does that mean that fewer people will be arrested and put into deportation proceedings? Does that mean that some existing deportation cases might be ended, or the government decides not to go through with them? Like what are the implications for immigrants on the ground?
I think the implications on the ground are not going to be that different. It's just that the ICE, Immigration and Customs Enforcement officials, now are not going to go out and just arrest anybody. They've got to follow these guidelines and saying, okay, you're a national security risk because of your terrorism risk, or you committed a crime, so we're going to put you into deportation proceedings. They still could pick up someone simply because they overstayed their visa or they entered illegally, particularly if they entered illegally recently, because that is one of the three guidelines. So I don't think that on the one hand, people out of status should feel, oh, I'm never going to be put into deportation proceedings. They still could. It's just that this allows the administration to try to prioritize who they will put into proceedings. As for those people who are already in proceedings, I suspect that lawyers may say, well, I should not be in proceedings, but these are only guidelines. They're not mandates. And so I think that ICE is going to say, no, we should go forward because this person is deportable. So it may not make a lot of changes on the ground, at least in the short term.
Yeah. So this ruling obviously is important for the deportation cases, for these priorities, but it also has potentially implications for future state challenges to federal policy. So can you tell us maybe about what might be the wider, or maybe not, significance of this decision on other relationships between the state governments and the federal government, particularly on immigration policy?
Well, I'd say there are two answers to that. First is at sort of the 30,000 foot level. We've seen a lot of states and immigrants' rights advocates suing federal immigration policies because they don't like them. And they always have to get over the standing hurdle to be able to sue. So if the ACLU, for example, sues because they didn't like the Muslim ban, they still had to show that the plaintiffs in the case, suffered injury because of the Muslim ban. This decision, on the one hand, could say, at least for states, you're not going to get that special solicitude that we talked about in Massachusetts versus EPA anymore. But there are enough caveats to the Kavanaugh opinion in United States versus Texas that it may not make a lot of difference. But it certainly raises questions like, when should a court intervene on immigration policy? If you go back to your high school civics classes, you learned about this tripartite system of co-equal branches. Congress is going to enact the laws, the administration, executive branch is going to implement the laws, and the courts are going to be referees to decide when either of the other two branches have committed some foul, whether it's violating the statute or violating the Constitution. we've got a broken immigration system, and Congress has been unable to pass immigration reform now for over 30 years. And so that means the administration has been trying to do more administratively than they probably would like, to try to see, well, what can we do within the constraints of this broken immigration system? And they have pushed the boundaries of what they try to do through executive action, et cetera. And that's caused problems and complaints, both by immigrants' rights advocates, depending on the administration, or by states. And so we've got courts sort of becoming immigration policymakers. And the question is whether this decision is going to restrict that, or whether it's just sort of a temporary setback for states like Texas and Louisiana.
Yeah, and we should mention, like, this litigation didn't start with the Biden administration. We can go back to the Obama administration was sued over the expansion of DACA, the parental program that they tried to implement, and that was taken down. President Trump was sued over a lot of different things, some by states. There were states involved in the Muslim ban, in the MPP cases, state of Hawaii, state of California, others. So this is not unique to the Biden administration, but this ruling, this particular ruling, could implicate cases that go back to the Trump administration that may be still pending, as well as some new cases, I may think. Can you share more on the concurrences? So again, for non-lawyers in the audience, you have an 8-1 decision and you have an opinion written by Judge Kavanaugh, but other judges who agreed also wrote their own statements, and those are called concurrences. What are they, and how do they differ from the main opinion that Judge Kavanaugh wrote?
So Gorsuch says, yes, I agree that Texas and Louisiana don't have standing, but I do it for different reasons. He said that Massachusetts versus EPA case really is a dead letter, and that states should not have special solicitude. And he said, Kavanaugh, I don't think that this distinction you made in your majority opinion between rulemaking on the one hand and arrest and removal and prosecutorial discretion on the other hand is really relevant to the standing question. That gets pretty technical, and we're not going to go into that. But he said, on a larger issue, I really think that this Massachusetts versus EPA case is a dead letter, and we should treat it as much. And that may be why the liberal justices joined the Kavanaugh approach, because as my colleague at Cornell Law School, Michael Dorf, who's a constitutional scholar, has written, the Kavanaugh majority preserves the case as a precedent for states to sue sometimes and seek regulation. So, for example, in Massachusetts versus EPA, there was a blue state, Massachusetts, that sought to require environmental regulation from the Bush administration. And so the three liberal justices may have joined Kavanaugh because in some cases they do want states to sue the federal government. They just didn't want it to happen here. Whereas if they had joined the Gorsuch opinion, that special solicitude doctrine would have gone out the window. In her separate opinion, Justice Amy Coney Barrett questioned Kavanaugh's, the majority's reasoning, saying that you're trying to weave together all of these confusing standing doctrines to create a rule that is novel and is in tension with other decisions. And it says, I think that another reason why Texas and Louisiana don't have standing is what she called redressability. We cannot redress what Texas and Louisiana should get, even if we agree that they should be able to sue on the merits. And then you have this, the dissent by Alito, who said, yeah, clearly Texas and Louisiana have standing here. And he criticized Kavanaugh for saying, this really has nothing to do with separation of powers. It really damages separation of powers by inflating the power of the executive and cuts back on the power of the judiciary. So it's a confusing opinion in terms of the various rationales of the different justices. But the bottom line is that, at least in this case, Texas and Louisiana could not go forward on their lawsuit.
Yeah. So as a matter of law, the majority opinion is what lower courts have to abide by. The concurrences kind of indicate where other justices may think differently, but it doesn't really change what other courts have to abide by. And the dissent is the same thing. I mean, obviously, the Alito was outvoted here, but are those sort of statements of, hey, if I were to write this is what I would say, and maybe future cases that come before me, you can get a sense of where the justices would vote on things. Is that kind of what those other statements are about?
Yes, many times justices write for trying to influence other justices for future cases, and that's why they may write a concurrence or a dissent. And sometimes those concurrences can become the majority opinion in the future. But here, all the lower federal courts have to at least abide by the outcome of this decision that Texas and Louisiana cannot sue on this particular prosecutorial discretion guideline. But Kavanaugh was very narrow, and he listed at least 5 different ways that on other immigration decisions, states could sue. And so we'll have to wait and see what happens on those lawsuits.
Well, then you wrote out one question I want to ask before we go to break, and that is, a couple of cases that we're going to talk about are pending or are state litigation cases. The first one is DACA, where Texas again is a plaintiff. I joke a lot that we have way too many U.S. v. Texas, Texas v. U.S., Biden v. Texas, Texas v. Biden cases. I can't keep them all straight. But in this case, the DACA case that's still with the district court in Texas, do you think, or it's kind of predictive at this point, how do you see this decision relating to that particular case?
In one sense, this Supreme Court decision will not affect the DACA decision because that's already at the merits. Texas and Louisiana survived the standing challenges in that case. And in 2020, the Supreme Court upheld the DACA program simply against procedural challenges, whether they complied with the notice and comment rulemaking requirement of the Administrative Procedure Act. And they remanded the case back down to the federal court in Texas to determine on the merits whether the DACA program violates immigration law or not, or exceeds the executive's power. So after the break, we can come back and talk about what's likely to happen in that case. But the U.S. v. Texas standing case is not going to affect the DACA Texas case because we're already past standing and now at the merits stage of that litigation.
Well, with that, we will pause so that we can come back and talk about a lot more litigation with Steve Yoelair. Thanks so much.
So we're back with Teresa and Steve to cover more litigation. Let's move on to an ongoing case concerning the future of the DACA program. Teresa, before we dive into the details of this case, can you briefly describe for our listeners what the DACA program is and why there's litigation over it?
Yeah. So if you've been living under an immigration rock for the last decade, you know that DACA stands for Deferred Action for Childhood Arrivals. So this was the program that the Obama administration created back in 2012. And it is a program that defers deportation for undocumented immigrants who arrived as children, arrived when they were minors to the United States. It also provides them with work authorization. So it doesn't give them a formalized legal status, but it does sort of mean that they can stay and work in the United States as long as they renew their status in this program every 2 years. And, there's been different attempts in Congress to try to create a lawful pathway for these people to get formal legal status in the United States. The program has, since its inception, been subject to, I'd say, some criticism and litigation about whether or not the Obama administration had the legal authority to do this. That having been said, over its lifetime, more than 1 million individuals have benefited from DACA. USCIS, U.S. Citizenship and Immigration Services, estimates right now there are about 580,000 individuals who have deferred action status. And theirs are not kids anymore. They may have been when it first started. Many of them are in their 30s and 40s. They have gone through college and university, or they are in the workforce. They have families and careers, and sometimes they have kids of their own who are born in the United States. But they have, for the last decade, benefited from these protections and work authorization to make their way in the United States. And I think one of the key issues in all the litigation and all the controversy about this program, and one of the reasons why there's a lot of support for providing permanent status to these folks, is because they have been here since they were children, grown up here. As I think Miriam Feblum said in our last podcast, these are people who are American in every way but the legal paperwork that says they are. And that reliance, the fact that they've been here, is one reason why Republicans and Democrats all say they would like to see permanent status allowed for this group of people.
And I would just add to that that DACA itself is an example of prosecutorial discretion. President Obama said, we cannot deport all 11 million undocumented people in the United States. So the people who entered without status or overstayed, have not committed any crimes, they should be the lowest priority. And the very title of the program, deferred action, means that, yes, they theoretically are deportable, but we're going to defer going after them. So they don't have a visa, they don't have a status. It's simply that we're deferring any deportation case against them. So it's another example of prosecutorial discretion, and it's one of the issues in the pending litigation.
Thank you, Steve. That's an excellent point. So it seems like DACA has been in the courts for a really long time. The Supreme Court has already seen a case about DACA once already. Can you tell us about the case history and where we are now?
Sure. So part of this issue arose because Congress failed to enact legislation to provide a path toward legalization for the DACA children. So the executive branch took action in 2012, and then Texas and other states sued, saying that the program is unlawful. The lawsuit challenged it both on substantive grounds, as violating immigration law, as well as procedural grounds, saying you cannot do this willy-nilly by simply coming out with a memo. You have to follow the rules of the Administrative Procedure Act and go through what's called notice and comment rulemaking. The federal district court, Judge Hainan in Texas, agreed on procedural grounds. And eventually that part of the litigation filtered up to the Supreme Court. And the Supreme Court in 2020 ruled that indeed the Biden administration or the Obama administration had followed the procedural rules and therefore struck down that aspect of the case. But they remanded back to Judge Hainan to decide on the merits, whether the executive branch had the authority to do this without going through Congress first. The trial court now has heard all of the evidence from both sides, and it was expected to rule on the merits soon. And I'm sure that no matter which side loses, they will appeal to the Federal Court of Appeals in the Fifth Circuit, and eventually it'll make its way back up to the Supreme Court for a decision on the merits.
Teresa, Congress has tried and failed during the Trump administration to pass legislation on DACA. There have been a few other efforts since then, including one at the end of last year, a bipartisan effort by Senators Kirsten Sinema and Tom Tillis that would have combined DACA legislation with border changes. Do you think this latest court case could prompt Congress to act finally?
So I think that supporters of DACA recipients and Dreamers in general certainly hope that a negative decision, particularly if it is upheld by the Supreme Court, would prompt Congress to act. I myself am a little bit skeptical. Not that I don't think there is desire on the part of many in Congress to enact legislation. And certainly Congress and many Congress people individually have used the excuse that, oh, well, this is in the courts, so we don't have to act right now. The courts, as Steve mentioned, have, in spite of there being ongoing litigation, have essentially preserved the program for many years now, at least for those already in the program. Now, one thing to realize is that because one of the requirements of the program is you had to have arrived in the United States before 2007 as a minor, there are many, 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 many people who've been brought to the United States as a minor since then, but after 2007, because we're talking about more than a decade now, 15 years, of people who are living their lives, graduating from high school, and not eligible for DACA at all. Because even if they allowed new entrants, those numbers of people who arrived after 2007 would not be eligible. So there's a big desire, I think, to do something for this population, whether it's existing DACA recipients or Dreamers and those who have arrived later. The challenge, I think, is a political one. We all know that we're going into an election year. The past attempts at trying to solve DACA have all been paired with some sort of border enforcement. And we've talked a lot about the challenges we're seeing at the U.S. border right now. You mentioned the Sinema Tillis effort at the end of last year. That was one such effort. And the idea is hopefully, this is all about how do you get the most votes in Congress. And the idea was, well, Republicans really want to see border changes. Democrats would really support DACA recipients. So if we put them together, we get Democrats and Republicans to vote for things. The problem is that when you start negotiating the details of these things, it's hard to kind of please everybody you need to please to get to the number of votes you need. And at the end of the day, I think at the end of last year, it was a lame duck session of Congress. They simply ran out of time to negotiate with everybody they needed to negotiate with. This year, of course, Republicans have control of the House. Speaker McCarthy, before he was selected Speaker, but Republicans have said, we are not going to do any quote unquote amnesty, no legalization programs while we control the House. So it's going to be harder this Congress, I think, to get something done on this. Would a negative court decision put pressure on Congress to try? Yes, I believe it would. We've talked about this Bipartisan Dignity Act that Maria Elena Salazar, Republican of Florida, and Veronica Escobar, Democrat of New Mexico, Democrat of Texas, introduced this year. That includes a legalization for Dreamers in it. Other bills have been introduced again. So there's vehicles out there. But I just feel like right now, maybe the politics would mitigate against Congress getting something done, particularly before a presidential election year. That could change depending on what the decision says, depending on whether or not people have their status taken away from them immediately, or whether the judges decide to kind of leave the status quo for now while all the appeals go forward. That's kind of been what's happened in the past. And that could Supreme Court may not see this for another year and may not issue a decision for another year and a half. So we could kind of continue to limp along where we are right now.
Yeah, just on a timing perspective, I think that with the slow pace of litigation generally, this probably would not be decided by the Supreme Court until sometime in 2025. That'll be after the presidential election of 2024. So Congress may say, well, while it's still pending litigation, we don't feel the pressure yet. And that pressure may only start to really be felt by Congress after a Supreme Court decision, and that'll be, after the presidential election. So on the one hand, DACA recipients shouldn't worry too much about their status being taken away immediately, but ultimately Congress should step in and provide some protection for these dreamers.
Thank you both. Finally, let's move on to a recent challenge to new restrictions on seeking asylum implemented by the Biden administration. Firstly, Teresa, can you tell us what these restrictions are and why the Biden administration implemented them?
So the regulation that the Biden administration put in place right around the time they ended the Title 42 order at the border is formally called circumventing lawful pathways. And what they mean by that is for immigrants who arrive at the border and try to enter, particularly between ports of entry, or who show up at a port of entry without an appointment, that there are restrictions on whether or not they would be able to actually ask for asylum. So opponents of this are calling it a transit ban or asylum ban, which is similar to a moniker that they gave to a Trump administration regulation that was eventually rescinded and struck down in court. But the main portions of this regulation are that if you arrive to the border and you have traveled through another country on your way, and you did not first try to ask for asylum in that country and were denied, then the United States does not have a responsibility to hear your asylum claim here. It's called a rebuttable presumption. So you're presumed not to be eligible to apply. You can rebut that. You can argue against that and say why you couldn't apply in another country, what made it impractical or improbable or whatever. There are reasons that you can do that. But on its face, if you've traveled through another country and haven't applied for asylum, you would not be eligible to ask for it here. There are a few other restrictions, one of which is if you come to a port of entry and you haven't used this appointment system that they have called CBP1 to apply for an appointment to present yourself and ask for asylum, again, you might be restricted from being eligible to apply for asylum. And then lastly, if you're from Cuba, Haiti, Venezuela, or Nicaragua, the 4 countries that have these parole programs in place, if you're from those countries and you didn't apply for one of the parole programs and instead came to the border and presented yourself to ask for asylum, you could be prevented from being able to apply. So this asylum restriction along with the requirement to use CBP-1, along with the parole programs, and along with certain other things like Mexico has agreed to take back people who were rejected under these programs for many nationalities, means that fewer and fewer people will have the ability to actually ask for asylum if they arrive at the border. And we've already seen a decline in the number of people arriving at the border and a higher, we just recent data, higher rates of rejection for people who have presented themselves for asylum at the border. So this is, I think, in many ways, the centerpiece of the Biden administration's strategy right now for managing immigration at the U.S.-Mexico border. It's a very important piece of how they're trying to manage the numbers.
So, Steve, this situation is a bit unique in that both the ACLU and the state of Texas are suing the Biden administration, but from different perspectives. So, let's start with the ACLU. On what grounds are they suing?
They're suing because they're saying this violates the immigration statute. They're saying that the asylum law does not allow any administration to restrict access to asylum simply based on how a person entered the United States or whether they applied for asylum elsewhere. And they say, as a practical matter, this requirement to seek asylum in transit countries is not effective because many transit countries don't lack a functioning asylum system, or other countries have systems that are stretched to a breaking point. And some are not safe for asylum seekers to find refuge. And they say that this mobile app, the CBP-1 app, is simply not working effectively. So, and they're saying that people who flee persecution have a legal right to seek asylum no matter how they get to the border. And they're basically following the playbook of the Trump administration challenges, saying that just as those should have been struck down, just as those were struck down, so too they should strike them down here. The ACLU has filed two lawsuits, one in California, and they have several other organizations suing with them, including the East Bay Sanctuary Covenant, American Gateways, etc. And then just last week, they filed a separate lawsuit challenging the same regulation in the District of Columbia. So that's pending. And we also have Texas suing on different grounds. So on May 24th, Texas sued the administration saying that by having the CBP-1 app as a requirement, they're actually encouraging illegal immigration. They're saying that having this CBP-1 app for migrants who don't have proper documentation actually means that they are allowing more people to come into the United States if they don't have a legal basis to stay. And it also wants to throw out the entire rule. And so we'll see what happens. Again, we talked earlier in this podcast about standing, whether the state of Texas has standing to sue on this. And both courts will have to decide standing not just for the state of Texas, but also for the American Civil Liberties Union.
So the ACLU is saying that this is limiting asylum. The state of Texas is saying this is encouraging unlawful migration. What is the administration's response to these challenges?
The administration is saying basically, hey, if both sides are challenging us, we must be doing something right. They're basically saying, well, if either of these lawsuits succeed, we're going to have more chaos and confusion at the border. As Teresa pointed out, with implementation of this rule right now, we've reduced unlawful immigrations about 70% since Title 42 ended. And that legal pathways like making an appointment to appear at a port of entry using the app allow the administration to process migrants in a safe and orderly and humane way, rather than this sort of catch and release of people trying to scamper across the border and hope that they don't get caught. So, we'll have to wait and see. It'll be particularly interesting whether any of the courts involved in these challenges issue what's known as a preliminary injunction, meaning that they block the rule from continuing while the merits of the cases go forward. That's what happened with the prosecutorial discretion guidelines that the Supreme Court finally struck down earlier this month. And if the courts were to issue a preliminary injunction, then we would have more chaos and confusion at the border because this new rule would no longer be in effect.
Steve, I'm going to ask you to pull out your crystal ball and make a prediction. How long do you think this case will drag on for, and what do you predict the outcome will be?
I think they will drag on for a while, just as we saw during the Trump administration. Lawsuits challenging Trump administration policies dragged on for a while. The key really is whether these plaintiffs, whether it's the ACLU on one side or Texas on the other side, can get an injunction to block the rule from going forward. And so I think that from the administration perspective, they're hoping that there will not be an injunction so that the rule can continue in effect while the merits go forward. And on the merits, I think it's going to be a couple of years before a court would finally rule, and then it would go up, perhaps eventually to the Supreme Court.
Teresa, given potential outcomes Steve just laid out, what do you think are the potential implications for Biden border policies here?
Well, a couple of things. If either of these cases succeed in taking down the rule on them, either temporarily or permanently, it's kind of irrelevant when you think about the migrants at the border right now. It would create a situation where frankly, tens of thousands of migrants who are in northern Mexico right now, kind of in a wait and see mode, will probably try to enter because the presumptions against being able to apply for asylum would not apply. The restrictions on the ways that you can apply would not apply. And so if they step foot on US soil, the administration would have to give them the ability to seek asylum. I think other parts of the administration's strategy here include expanding other so-called lawful pathways. They have expanded other parole programs for people who are beneficiaries of immigrant visa petitions and are waiting a visa before they could enter the United States. These parole programs would allow basically family reunification. So a person in the United States, a citizen or permanent resident, has filed on behalf of a brother, a sister, a mother, a spouse, an adult child, whomever who qualifies, but they can't come in because they're waiting on a visa to be available in that category. It would allow them to come into the United States and wait in the United States, and so that family could be reunited. So they've announced some expansions for certain nationalities to do that. They've also tried to expand work visas for Central Americans in the H-2B category. And they've opened up recently these regional processing centers to hopefully help people understand whether they qualify for asylum at all, or if they would potentially be somebody eligible for refugee resettlement so that the government could bring them to the United States. I think the administration would hope that those other pathways could be taken up. But as I mentioned, you already have people who've already left, who've already made that decision, who've already come to the border, who are sitting in northern Mexico without really any options. They're not going back home, not unless they're forced to. And they're just sort of waiting to see, do they wait and see if this comes down and then they can come in? Do they try to sneak in? It's an individualized decision based on what's happening to them right now in Mexico. Do they feel like they're unsafe there? Are they able to make a living for themselves? Do they have people in the US who are waiting on them, family members or friends who would be willing to take care of them or offer them the job? That may encourage them to come in regardless of what happens here. But I do think that the resource issues are key. And you heard Steve say that the government's response to these courts, their first response is, if you do this, if you take this down, we will be back to an unsustainable number of people crossing the border, and we don't have the resources to deal with that. And that's a big problem. Regardless of whether or not that's a valid argument to the court, when what's being argued is that what you're doing is illegal, I can't say. But the operational reality is they're not wrong, that it is likely we would see unsustainably high levels of migration at the US-Mexico border again if these rules were to become taken down.
Thanks so much, Teresa. That is all we have time for today. Steve, thank you for joining us on This Week in Immigration. And to our listeners, we'll see you next time. And that's it for our show this week. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all of the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on Twitter at BPC_bipartisan. You can follow Teresa Cardinal Brown at BPC_T Brown. For feedback or questions, you can contact us by emailing immigration@bipartisanpolicy.org. I'm Hanadi Jordan. This Week in Immigration was created and executive produced by Teresa Cardinal Brown. This week's episode was written by Hanadi Jordan, Natalie Butler, and Teresa Cardinal Brown. Our audio editor is Joshua Joe. The executive producer of BPC Podcasts is Lucy Manning. See you next time on This Week in Immigration.